But
Go.
you just mentioned, Ms. Hawley, sort of two theories, the associational harm theory and the pre-enforcement review theory. Could you explain to me how you view the difference between those two theories and the scope of each, and why it is that you have emphasized one? Do you prefer that one, the associational harm theory? Why? Why isn't the pre-enforcement theory the way to go here?
So to answer that last question first, we're perfectly happy with the decision from this court under either theory. Under our associational harm theory, we think what First Choice needs to show is that a reasonably objective donor or nonprofit, as described as a person of ordinary firmness, would have been chilled by the coercive subpoena. We think that's clear here. Under the second theory, the pre-enforcement theory, what First Choice would need to show is a credible threat of enforcement. Again, enforcement's already occurred. The Attorney General does not and cannot dispute that. In addition, you need to show that your constitutional or federal rights were arguably burdened. Again, there's no question the subpoena arguably burdens First Choice's First Amendment rights. As far as scope goes, Your Honor, we don't think that either of them would open the floodgates. With respect to the pre-enforcement theory, there are a couple of procedural safeguards built in. To begin, you would have to satisfy the other requirements of SBA list. Basically, you would have to show a plausible federal cause of action. In addition, you would need to show irreparable harm in order to get a preliminary injunction to enjoin the state official. In most cases, outside of the First Amendment context, we think that would be relatively difficult. So we actually think the scope of those two different theories will be relatively similar, again, because of that requirement of irreparable harm.